Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-3 spouse visa. And I don't discuss this one on its own all that often for a variety of different reasons, but one of the big ones is that what's called the doctrine of administrative closure. And that doctrine is maintained by the Department of State for when an underlying petition for an immigrant spouse visa, which that's the usual CR1, IR1 visa, when you have to file for one of those in order to file a supplemental petition for a K-3. The reason I bring this up is because the K-3 supplemental petition, if it is adjudicated after the underlying I-130 petition, then they'll just close that and they'll just maintain the I-130 petition. You'll be stuck with the IR1 or the CR1, stuck if you will. If you proceed on the K-3, then the question becomes, are you work authorized in the United States? And I'm going to go ahead and go over here to uscis.gov under K3/K4 non-immigrant visas. If you are admitted to the United States with a K3 or K4 visa, you are automatically authorized to work based on your status. Okay, so again, USCIS can engage in some doublespeak here. So at first you're like, oh, I can just work. But to obtain evidence of employment authorization, you may file Form I-765 application for employment authorization at any time after being admitted to the U.S. Alternatively, you may file an application for a green card and then apply for employment authorization based on that pending application, even if your K-3 or K-4 non-immigrant status expires. So it's very similar to the K-1 fiancé visa insofar as, yeah, they say it's work authorized, but then you need to get evidence of your work authorization. So effectively, it's not until you get your employment authorization documentation. The other thing to bear in mind with the K-3 is in order to get into green card status, that's lawful permanent residence in the United States, much like the K-1 fiancé visa, you need to adjust your status in the U.S. So that's a major difference between that visa and the underlying I-130 or CR1 IR1 spouse visa. In certain instances, the immigrant spouse visa may be far more advantageous than the K-3. That being said, depending on the circumstances, timing may be a major issue and the K-3 may be a better option. It's always going to depend on the underlying facts in a given case.